All right, good morning or good afternoon, everybody, depending on where you're joining us. I want to thank everybody for joining us today for our WorkComp Blitz episode. And today we are fortunate enough to have attorney Jesse Bernal join us.
Thank you.
For the topic, how to dominate your deposition. Tips for maximizing information gathering, attacking credibility, and positioning your team to win. And today, those handsome gentlemen are also in front of you here. I am Josh Diggs, Director of Claims at Orion Risk Management.
And I'm Jesse Bernal, the principal of Bernal and Robbins.
And so the topic today, I think, is important in workers' comp for a couple different reasons. And ultimately, for the deposition, the entire claim can hinge on how this deposition turns out. In many cases, our first engagement with the employee or claimant can be during the deposition. So we have no idea as to how they're arriving at these allegations until the day of the deposition.
Most definitely. And why the deposition is important is it's generally speaking the only tool that a defense attorney has to test the veracity of the statements. That is, as it relates to the mechanism of injury, prior or subsequent accidents, or claim restrictions.
Yeah, good point. So the way I see it is there's three stages of a deposition. There's the prep work that goes into the deposition. There's a deposition itself, and then there's all the information and the next steps that we do after the deposition itself. And so I'll lead into a little bit about the prep work, because the assistance that I can provide as a claims advocate is all the work that leads up to the day of the depo, when the attorney would obviously take over. So a few things that we would do leading up to the depo is, first thing is obviously you want to know your file. You want to make sure that you understand the facts as much as possible, that you've had an opportunity to review the strengths, maybe the weaknesses of the file, that you've talked to any witnesses to help corroborate any statements as far as the allegations as you know them. Maybe you would have had access to the personnel file, or you should have had access to the personnel file to review for any absentee, tardy issues, just performance challenges. If there was a termination before, or that led to the claim being filed, then you would definitely want to make sure that you had all the details leading up to the termination and the reasons for that.
You know, as a defense attorney, if I don't have sufficient information to take a deposition, like a personnel file or perhaps initial medical records, then it may be better that we delay the deposition. So it's always good to have that information ahead of time.
Yeah, you definitely want to have all that headed into it so you're as prepared as possible. So a couple of things that we do, again, in advance of the depo is, whenever possible, I want the employer rep to be in attendance at the depo. There's a lot of reasons for that, but I think the most striking is that we're going to help as best possible any blatant exaggerations, any blatant lies that a claimant could testify to, and also someone there that ideally would know the applicant and would have an understanding of the claim, that could tap the attorney to say, yeah, that's not the case, and share that with you so that you can then follow up with some very specific line of questions. There's no doubt about that. There's a lot of benefit in having an employer representative.
Well, there's the benefit of having an employer representative, but there's also an importance of having the right person attend the deposition. Because sometimes when you go higher up the chain, you may have the person attending the deposition with authority to negotiate or with the settlement money, but not know the facts of the case or do not know the applicant. So it's always good to have perhaps an on-site individual or supervisor attend the deposition instead.
Great point. And that kind of leads into the next point is everyone should have an agreement as to what settlement authority, if any, is going to be relayed at the depo. So the attorney should fully understand, Jesse, you have $2,500, $5,000, $10,000 in advance of this depo based on our understanding of the current facts. It could be a nuisance value settlement. There could be a lot of things that come into play there, but at the very least, there should be an agreement in advance of the depo as to what, if any, settlement authority you are going to have.
Most definitely. And then when you look at the strengths part of this section, it's important to know this, whether it's a long-term versus short-term employee. Obviously, one's going to potentially generate a higher settlement demand or settlement authority than the other. So it's always important to know, again, your strengths of your case.
Yep.
Post-termination, fired, caught for stealing, or just a layoff.
Yeah. So a couple other things that a carrier is going to want to share with all parties in advance is the ISO index report and EAMS, right? So if there's ever been any prior claims, then obviously an attorney is going to want to know that in advance so that you can direct your line of questioning that way to really drill down on who they treated with, what they treated for, were there any settlements, so that subsequently we can go and obtain those records and again start to fortify that defense.
Most definitely. Oftentimes when we do the prep work for a deposition, obviously again, having the sufficient information and documentation, having the pre-depo conference, but most of all, setting goals and expectations of what we expect to get out of the deposition. In certain situations, if we're going to be trying to quickly do a nuisance value settlement, we're going to be asking obviously for the settlement authority. If we understand that this is going to be a long, a depo of an individual who's a long-term employee, well then we know this might go into a long ball type game.
Yeah, great point. You mentioned the pre-deposition conference call. That's something that I'm a big proponent of, because in my opinion, before we head into a deposition, I like to gather all parties associated with the claim. Defense attorney, claims examiner, supervisor if necessary, claims advocate, employer. I like everyone to get together so they can flesh out all the details. And there's times where information that someone may not think could be pertinent, that all of a sudden can absolutely assist us in the defense of any claim or the approach that we take. Things like hobbies, activities, things that they may have said before they were terminated. They could be friends or somehow be related to a person that has an open claim, right? So all that can factor in, and I think during that call, that pre-depo conference call, everyone can kind of weigh in, and then we also all agree upon the action plan that you guys are essentially going to execute on the day of the depo.
And another benefit of that pre-depo call also involving the claims examiner. It's important because in certain situations, I may not have a document right then and there. During the conversation, it's like, bleep, here it is. I just sent it to you. So information can be on the fly. And at that point, we can obviously roundtable the discussion of our goals and also discuss particular topics, perhaps reasons why this person may have filed a claim to begin with.
Yep, good point. So I think we've nailed down that prep work is paramount.
Yes.
So that you can have as much ammo and a strategic game plan as possible. So let's dig into the deposition itself. And I know in our prior discussions, you kind of nailed down sort of the three-prong approach or keys that you look into or look for on the day of the deposition. So why don't you kind of dig into those a little bit?
Most definitely. If we've done, obviously, the prep work, then we're going to be able to attack and or impeach the applicant in three categories. Basically the first one is mechanism of injury and claim body parts. The second is prior or subsequent accidents. And also with the prior or subsequent accidents, we can also delve into concurrent and subsequent employers for the right type of case, CT claims. Also, the next part is claimed restrictions. Those are the three areas that I focus on every deposition. And again, we're able to test the veracity of each of those statements, compare them to perhaps what's written in a medical report, what was stated in the initial report of the injury, the descriptions, any witness statements. We can test the veracity of those statements.
So I'm going to jump ahead a little bit here, Jesse, but one of I think the key drivers of litigation in general in California is going to be post-term cumulative trauma claims, right? So, and I know this could be an hour easily in of itself, but why don't you give me an idea of what you look for on a post-termination CT claim when you are deposing an applicant?
Well, again, long-term versus short-term employees is a different type of deposition. However, what's the same for both of these is this. Did they know they had an injury prior to the termination or layoff? And if so, why didn't they report it?
Got it. So really, that's what it comes down to. I mean, of course, it's going to be a 2-hour plus deposition, but the goal of that deposition is to pin them down to actually having an accident or notice of pain or symptoms in which, if I understand correctly, you're trying to pin them down to say this wasn't a cumulative trauma claim. This was a specific claim that you actually never reported.
Exactly. And that would be the basis of a statute of limitations. But again, setting the goals ahead of time, you know what exactly you expect to get accomplished out of that deposition. So again, if there are claimed injuries or events that happen on a specific date, then we can turn around as to a specific date of injury and then potentially recommend the denial of that claim based on statute of limitations.
And I'm jumping ahead a little bit here too, but I'm curious. There's a couple different schools of thought here. What is your thought as a defense attorney actually doing the deposition, surveillance before depo and surveillance after? I know the answer is going to be, I'll take both. But if an employer is cognizant of costs, what is your strategy? You prefer to have that surveillance in advance, or you prefer to kind of wait till you get some testimony, maybe for more targeted efforts?
Well, if it's done in advance and I'm able to get the video ahead of time, then I'm able to ask specific questions of certain activities that might have been seen on, the surveillance. For instance, they claim they can't move in, not even the trash cans, and yet you see video of them moving in and out their trash cans. So certain activities, if we have the video ahead of time, then it would be nice to have it before the deposition so I know how to ask the questions. But obviously, the purpose of the deposition, as I said, test the veracity of the claim restrictions. We can have that bar set right then and there as to what they can and cannot do. And at that point, we can turn around and have that given to the person doing the sub rosa video or the surveillance to basically keep an eye out for that specific activity. And it's important.
Got it. So I think that kind of brings us to the third stage of a depo, and I call that the after depo, right? The post depo. What do you do with the information that you gathered? Because in order to really determine, did we dominate this depo, a lot of it is dictated on the information or your next steps after the deposition. Could that mean we tore down their credibility and there's an opportunity to settle it? Then that might be ultimately considered a domination of a depo. The reality is, in some cases, some information will come out of a depo that leads us to believe, hey, this is a claim that we're going to have to accept. And rather than kind of have to continue out this, string out a denial, if you will, we got the information that we need. Now we need to maybe maybe we need to accept the claim and then consider mitigating the cost. But ultimately, what we do with that information is going to help dictate, whether or not it was a successful deposition.
Well, you start out with the title there, settlement. It's always good to know what you're going to do. If this is a type of case, you're going to figure out whether you're going to do a cost-benefit analysis. In other words, is it better for us to quickly settle for nuisance value now? If we've obtained great information from the deposition, perhaps impeachment information where the person denied a prior or even subsequent injury, or even perhaps we have information of concurrent employment and basically states nothing ever happened there, or it wasn't as a result of that injury. But understanding whether we're going for bust, that is, we're going to try to settle right then and now. Obviously, it's important to understand where we're going with the case, but also to understand if we also need to push forward to trial, or at least posture towards trial to force a settlement. So if we obviously are pushing forward towards a trial, then again, as you notice, the subpoena of records and the surveillance can all be coordinated correctly. If we've gotten information as to subsequent employers, concurrent employers, we can obtain the subpoena of those records and determine what exactly is he doing. Right? Oftentimes they'll state, my job's a lot easier. I'm not doing any lifting or anything like that.
And I think more importantly is if we get notice of subsequent or current employment, along with obtaining those records, now there's an opportunity to bring them and join them as a party to the claim. If they're doing the exact same line of work, which we see quite a bit, now we make the case to the doctor that this is an ongoing cumulative trauma claim because they're doing the exact same line of work. So it didn't end on this date. In fact, it's ongoing, and now we need to join that new party. And then all of a sudden, that's going to ruffle some feathers, and that might change the stance on settlement. And really, the doctor could open their eyes if they weren't aware of any concurrent or subsequent employment.
As a matter of fact, it often does. A current employee who was your former employee may not want to bring in his current employer because he loves his job or he's there making money, whatever, for whatever reason. So in certain situations, when you advise the applicant's attorney of our potential need to bring in a subsequent employer, they may want to settle. And again, those facts would prove quite helpful, especially in extending the CT, because now we're in a position where we now extended the CT to perhaps a previous year, which may now eliminate our responsibility. Again, it's the last year of injurious exposure. So it may no longer be ours.
Yeah, absolutely. So I think we talked about positioning your team to win. I think those are some key components there. Identifying concurrent employment, looking for an opportunity to share some of the exposure, if any exposure, or pass it on to someone else. Accurate medical history, you touched on the importance of that, making sure the doctor has a full understanding of any priors that they may have omitted or maybe kind of brushed over. So that's all important. And one thing too is, and before we get to a few additional tips, is I think it's important, and we talked about this as well, is really defining what a win is, yes. Right? For some employers or some carriers, taking something all the way to trial can be considered a win.
Yes.
On the other hand, recognizing that there's a cost-benefit analysis in some instances, particularly high-retention employers, and it's their money, they might have to make a financial decision. They might have to consider settling a case that they feel is bogus if they can avoid the prolonged medical liens, EDD lien, defense costs, QME med legal panels that can be anywhere from 5 to sometimes 10 grand if it's a psych, QME. So sometimes they have to make a financial decision. What's important to know is what is the win? And the win ultimately isn't going to be dictated by yourself, myself. Yeah. Ultimately, it's the employer or the client, right? And the carrier in some instances, yes. They're going to help dictate what the win is. And so when we understand what they feel the win is, that's going to help dictate our strategy at Depo and again, post-Depo.
Again, a win oftentimes is paying what you owe, especially in situations where you're dealing with long-term employees. A doctor is going to find an injury. I mean, that's a given. In certain situations, they may not find all the injuries they claim, which is obviously better for us. But a win is always, we pay what we owe, not a penny more. However, in certain situations, mitigating our losses is a win. Cutting our costs down from perhaps further litigation. Also, perhaps if we do, in fact, take it all the way to a trial, we get to take nothing.
So I think the key takeaway there is just knowing what a win is for your client, whether it's the employer, whether it's the carrier. Help them understand what a win is. Is it saving costs and shutting the claim down and mitigating it? Or is it sending a message? We know how important that is for employers.
Yes.
They work in let's say they work in a manufacturer that works in a small environment, 200 employees. If they get a sense that we're going to settle a post-term claim for $20,000, which they deem unreasonable, if they feel that is going to prompt 4, 5, 6, 7 other claims, then that settlement is not going to be considered a win. And that's where we might need to dig in and kind of set it up for trial. So I think it's always important to be cognizant of the end client, what would they consider to be a win, and then tailor the approach accordingly.
Exactly. And obviously, just to add to positioning your team to win, it's also important to know that during the deposition, we're clearing up facts that will later be brought to a doctor. So if the doctor, hears that the applicant complained about his knee, it wasn't filed in an application, it wasn't stated in the deposition, then arguably there is no basis to now consider that in the industrial. So it's obviously, making the medical history more accurate. Also, again, determining the CT and the causes. So, the facts and information gleaned from that deposition can be priceless.
Absolutely. So I've got a couple of just one-off kind of tips that I couldn't find a way to place on anywhere else here. And I think this is more of a engagement piece, but one thing that I found formerly, being on the claims desk, was the importance of being available during the deposition. The person that has the settlement authority, whether it be the risk manager, the WorkComp claims manager, the claims examiner, whoever has, the checkbook, if you will, that person needs to be available on the day of the deposition, because we could have gone into this thinking, well, this should settle for $5,000 because it's a BS case and we've got all of these things in our favor. And they could blindside us with saying, well, before I was terminated, I let my direct supervisor know, and maybe we overlooked that, didn't check with that person, say, oh yeah, sure enough, he told me. That could absolutely blow our defenses out of the water. And so something like that on the fly, if you identified, well, we need to shut this claim down, that person, the facts have now kind of changed, right? And we need to be available to say, I need another $5,000. This one is worth shutting down. This new information was brought to our attention today, and we need you to be flexible. And so long as you can justify it, then the importance is being available. Because the last thing you want to do is call an examiner who's in a conference call, their supervisor's on vacation, their covering examiner has no authority, and then we're left missing an opportunity, and 2 weeks later we get a demand for $30,000 when maybe $10,000 could have shut it down that day. So to me, that was always available. Was really important.
Oh, I agree. As a matter of fact, I've been in situations where I could have settled it for 10, but because I didn't have the additional authority or the people weren't available, it ended up settling for a few thousand more on top of that.
Yeah.
So
the way I like to get around that is, as a defense attorney, not me, but as you being the defense attorney, I like to make sure that you have the decision maker's cell phone. You've known, and sometimes text is all it takes, right? You're in the middle of negotiations. Hey, I need another $3,000, and being able to have access to that person, even by text, to get things done, and that's that can be a game changer in a situation where you don't want to lose that opportunity.
Yes, definitely.
I'm kind of curious, because I've been told that you've got some fairly legendary depositions, and where you've even told people to bring popcorn to the depot, especially when you know it's going to be a fun one. So help me understand how you like to approach a deposition. Do you prefer the chronological, sort of as we see in the movies? Give me your name, your address, how long you've been working here. Tell me how you like to, your cadence, your rhythm to help throw things off.
Straight to the crux of the matter. In a post-term case, question first out the gate is, are you claiming injury for what? I don't ever go through the history. I'll generally get it at the end. Anything dealing with post-termination, like for instance, why were you fired? Or, why were you laid off? Or were you aware there was a layoff? When? So always to the crux of the matter, because oftentimes in situations you'll find applicants' attorney trying to continue to a second depot. So if you're going through the general background, you've already missed the opportunity to be able to ask all the important questions you wanted to ask that they're going to make you sit in a second deposition. So in that situation, I just get to all the questions that I deem important immediately. Like I said, I set a goal, and I often write it on my sheet. What are the key questions I want to ask and make sure I get out? I generally go for that first. Anything having to do with a termination.
In that situation where you go right to it, I'd imagine the applicant attorney probably hasn't prepped their claimant for that. What's the response usually?
Well, yeah. What does this have to do with the underlying injuries claim? Well, I'll bring them to his attention. By the way, this is, mind you, this is a post-termination claim. So the underlying basis of this termination, perhaps to deem it retaliatory, is important in determining the validity of this claim. So oftentimes you'll have applicants' attorneys go, oh yeah, you're right, okay. So, and then...
Do you find that the claimants get rattled with just coming right out the gate with those kind of aggressive line of questioning?
Yeah, they do, because the prep generally goes in, well, they're going to talk about your history, they're going to talk about your injuries, make sure you remind them that your knee hurts, this hurts, whatever hurts, Because then when the deposition comes and you get a question out of left field, they're already razzled from the beginning.
I like that. And you've got an interesting approach when it comes to depositions as it relates to 5710 fees. Those are the fees that are paid to applicant attorneys for time, preparation, and just the cost of attending the deposition, which is a nuisance for a lot of employers and carriers. But you've got an interesting approach. When you identify or suspect that there might be fraud, what is your stance on paying those 5710 fees?
Well, if I can confirm that the person lied in the deposition, what'll end up happening is we'll receive a 5710 demand. And what we do is we send them a letter just advising them of a particular case called Golden Eagle versus WCAB, which basically states that if we suspect fraud, and it's got to be articulable in the sense that they lied about certain things in the case, then at that point I'll apprise them that we can now defer 5710 fees until the resolution of this case.
And that obviously does a couple different things. It's going to send a clear message to applicant attorney that as everything is lined up, we're not messing around. We're in this for the long haul. We're willing to litigate these issues.
Definitely.
We feel strongly about it. And obviously the facts would need to support it.
Yeah.
But I think it's telling the applicant attorney, look, you're either going to need to dig into, or you're going to need to say, look, recognize or acknowledge that your position is not strong on this, and maybe they need to buckle on whatever ridiculous demand they have. And now you might be in a position to consider nuisance by itself.
Most definitely. I mean, when you start messing around with attorney's fees, specifically 5710 fees, which almost everybody pays without blinking an eye, it just doesn't. But if you can show them that the applicant lied, perjured herself, in that situation, I'll send the information just saying, by the way, as the applicant testified this, that, and the other, here's where it's not true. So if you intend to push forward, then, we're going to defend ourselves. And oftentimes, it's also important to know if and when you do, object to 5710 fees on that basis, oftentimes, and I've told you this before, they may file or claim to file a petition for cost and sanctions, which, by the way, the law is very clear as to this issue. So I've dealt with it a lot, and generally speaking, oftentimes we've reached a nuisance value settlement, and then we had to resolve it. Also, in certain situations, the 5710 fees for nuisance value as well.
Laura, did we have any questions emailed in? Or ladies, did you have any questions?
I do have a question regarding the case that you cited, Golden Eagle versus the WCAB, regarding false testimony by an applicant under oath. Can you give any more specifics regarding whether or not the court looked at materiality? So, for example, if they stated, I just had a depo probably a couple of months ago where the employee was testifying that they had a job at UCR prior to coming to work for our hospital. The employee never worked for UCI. So is that the type of thing that we could use to avoid those 5710 fees, or would it be something that went to certain treatment, or whether they'd ever claimed an injury?
You're right as to materiality.
Okay.
The important thing is if it has to a history, something that's going to be deemed insufficient or insignificant, did it really matter whether he worked there or not? Perhaps in a different scenario where that coupled with other things, I'll give you for instance, we had a situation where the applicant on his LinkedIn profile and on Facebook had stated that he was the regional manager for that particular company. I had the regional manager sitting right next to me. So in certain situations, that coupled with other potential misrepresentations, yes. But that in itself, no. But obviously, you can use that to later impeach the applicant at a subsequent proceeding. But again, more as to injuries, perhaps treatment, claim body parts. In situations where I've had applicant come in with a neck brace after they had a neck surgery, but actually Sabrosa video 2 months before had shown her not wearing this, walking around normal. And I got her to confirm in the deposition that she's been wearing that neck brace ever since the surgery. So in that type of situation, as to the treatment, something material as to the underlying case.
Yeah, I think I think what's nice to know is it's another tool in the tool belt. It's an ultra aggressive stance, but I think it's sending a clear message. You definitely want to be able to substantiate it, and you want to make sure that ultimately the employer, the carrier, the TPA is going to be okay with us taking this stance because the applicant attorney may very well litigate it. It sounds like we have enough to be able to defend it, but just know that there might incur some additional costs. But it's something you'd want to agree upon in advance, but I think it's taking an ultra aggressive stance that can send a message. And so if that's what you want to do, and this is one that we might want to ratchet up for trial, then that's the route that we want to take.
Most definitely. And like many things, oftentimes I'll send a letter. Look at, I'm willing to consider your 5710 fees, but here's what you testified to. Let's discuss this so that perhaps we can clear up the issue and see what we can do with regards to your fee and perhaps settling the underlying case. So I put the applicant in a position to say, look, I want to help you here, but here's the problem, as opposed to just saying, no, I'm not going to do it, and here are the reasons why. There are times and reasons for that type of stance versus trying to be, a little bit more cordial about it, of not paying them.
And so Jesse, Luis, a risk manager, wanted to share something. He mentioned that on his claims, he recommends a social media investigation prior to the depo. He's found some good results. I would absolutely concur with that. I think it's in lieu of what we talked about, sort of the cost associated with it, where 2 or 3 days worth of surveillance, that could be $3,000, $4,000, $5,000. A social media background check, I think, is going to provide at a low cost quite a bit of return. You can find how active they are, activities of daily living, just get a sense of what they might do, help you with some very specific questions, and maybe even lay the groundwork for some surveillance.
Yeah, as a matter of fact, social media helps quite a bit because almost everybody's on social media. I mean, we send messages via LinkedIn, some people do Facebook, but in that particular scenario that I gave, that person had listed his job duties of being something more than he was. So that was helpful to use in the deposition to obviously make the deposition go a certain way.
Excellent. Well, I think we went a little bit longer than we expected, but I think this is a topic that has a lot of meat to it. And I think that, again, the entire claim can potentially hinge on this. So I think it's really important. I appreciate everybody joining us in attendance and also joining us via our webinar. And thanks again. And we look forward to letting everybody know about the next one.
Most definitely. Thank you for having me.